Ladies and gentlemen, Andres, can you see my PowerPoint and can you hear me now?
Yes, I can see the PowerPoint.
And is
Loud
everybody,
and clear.
and everybody can hear me now?
Yes, I presume so. Yes. As long as that I can hear you, everybody should be able to hear you. Yeah.
Okay. Ladies and gentlemen, I'll have to start all over again, okay? So I'm sorry, Renee, that you'll have to listen to it over, but repetition is always a very good thing. Right, so as I said, 2 weeks left for the exams. At 4:30 this afternoon, Anton Tron is going to have a little talk to you about the exam. He's prepared the exam papers. I think you can ask him some leading questions. I'm perhaps being facetious now, but let's leave it till 4:30, then you can speak to him. Time is of the essence now. What we're doing now is certificates of title. Just to summarize, I say the certificate of title is an extract of facts which the Registrar of Deeds provides a owner of property with of existing registered facts in the deeds office. This means that the certificate of title cannot include any new information. For every certificate of registered title that you're going to have to know, there is a prescribed form, and it starts at prescribed form JIILMNORV. And all the certificates of title that you must have a working knowledge of is between section 34 and section 46 of the Deeds Registries Act. Section 37 is the umbrella section which governs the issuing of certain of those certificates of registered title. So once again, I say, Renee, you've heard this and you're going to hear it again. It will be very seldom, it will be very seldom for the examiners to ask you to prepare a certificate of registered title, except if it is a certificate of consolidated title. All the others that they will request you to prepare, they won't ask you to prepare the certificate as such, because otherwise you would just be rewriting the prescribed form. However, they would ask you to draw the application of the document that you're going to lodge at the deeds office for the issuing of a certificate of registered title. And that would be either in terms of section 34.1, 34.2, 35, 36, 39.1, 39.2, 40, 43, or 46. In terms of section 34.1, it is obligatory for a co-owner of property holding that property under the same title as his co-owner to apply for a certificate of registered title if he wants to mortgage or if he wants to sell an undivided share or a fraction of his or her share held under that joint title. So in certain instances, section 34.1 and section 34.1a is obligatory. You will use prescribed form J, and you will use that as a cheat to prepare your application. Your application, as I said, the heading, don't say application in terms of section 34.1, because it's not an application in terms of section 34.1. It's an application in terms of section 37. You're applying to the Registrar of Deeds for the issue of a certificate of registered title in terms of section 34.1 or 34.1a. But the application is in terms of section 37. This might sound confusing. That's why I'm saying to you, in your heading, don't say anything. Just say application. Then it will be, I, Alan West, identity number status, do hereby apply to the Registrar of Deeds for the issue to me of a certificate of registered title in terms of section 34.1 or 34.1a in respect of 1/2 share, earth so-and-so, and township, registration division, province, measuring, held by deed of transfer signed. So this application that for you to draft should not cause any hardship. However, you must know the contents of section 34.1, because they usually ask that perhaps in your first paper as a theory question. Under what circumstances must you lodge a certificate of registered title in terms of section 34.1, as an example. Section 34.2 is where that joint title that we discussed now is lost. Now, under normal circumstances, you will apply for a VA copy, or what we call a certified copy in terms of Regulation 68. This section just makes it more convenient for a co-owner to apply for a certificate of registered title in respect of his or her share without having the other co-owner also being a party to the application. Because maybe the other co-owner, you cannot find him, or whatever the case may be, or he's dead and the executor hasn't been appointed and you want your title deed. Therefore, you can apply. However, the provisions of Regulation 68 is mutatis mutandis applicable. So you will also have to give an affidavit to say that that title deed has not been mortgage pledged or held as security, or if it's mortgage pledged or held as security in terms of a bond, then you'll have to get the bondholder's consent in terms of Regulation 68.2, because 68.1 and 68.2 is mutatis mutandis applicable to a certificate of registered title in terms of Section 34.2. Section 35 is the amalgamation of shares. This is prescribed Form I. I am the owner of a property and I bought that property from my co-owners over a period of time. I first bought a quarter share, I owned a quarter share, and then I bought my other quarter share from my other co-owner, then another quarter share, then another quarter share, then another quarter share. Now I've got 4 quarter shares held by different titles. I don't want to hold it under different titles. I want to hold it under one title. It's not obligatory. I can ask the Registrar of Deeds for a certificate of registered title in respect of that property held under those title deeds, or that share in the property held under those title deeds. I said that I think 2 or 3 exams ago, this question was asked for 15 marks. Just draft the application. Guys, it was a travesty to see how people were drafting this application, not knowing which section, not knowing that it's an amalgamation of shares, not knowing that you must, if it's an amalgamation, to say in that instance it was 5/8 share, and then you must say under what title deeds the respective shares are held. So I say once again, this is not rocket science to prepare this. You must know under what circumstances you can use your prescribed form as a guide to prepare this certificate. Section 36 is a certificate of registered title where you have a title deed with more than one property in that title deed, meaning I bought 5 pieces of property from a developer and it is held under separate paragraphs, as we call it, in our title deed. And maybe I want to now mortgage one of those properties, or I want to sell one of those properties to the state, and the state wants to do it on a cost-effective basis in terms of Section 16. Then I will take out a certificate of registered title in terms of Section 36 for that one property. However, Section 36 clearly says you can never exhaust a title deed by the issuing of certificates of title. So the application shouldn't be a problem. It's not obligatory. However, in certain instances, you will. You will note that there was a conference resolution. I think the conference resolution was in 2014 or 2015. They said, if I'm going to register a mortgage bond over one property and there's 6 properties under that title deed, must the owner take out a certificate of registered title? And the registrar said that's got nothing to do with the deeds office. He can, but he's not compelled to. The financial institutions will love getting a title deed with 6 properties, because not that their real security is increased, but they got a title deed with 6 properties in it. And you cannot deal with it because they hold their title deed. So 36 shouldn't be a problem. 38, those of you that are well conversed with the deeds office practice and procedures will know that in 2007, the Pretoria Deeds Registry lost 400,000 images. So the possibility is that if you looking for a 2007 deeds office copy of a title deed, mortgage bond, antenuptial contract, lease agreement, servitude, that the deeds office will say to you, we haven't got that title deed. In Cape Town, for instance, there was a flood, and a lot of their books in their strong rooms was destroyed. There was a fire in one of the smaller deeds registries, and mice got into the strong room in one of the deeds offices and ate up a lot of the registers that they have with deeds in it. So the possibility is that the deeds office can lose their deeds if those deeds weren't microfilmed and it was backed up in a certain manner. Those 400,000 images in the Pretoria Deeds Office was not backed up, therefore there was no backup, therefore it is gone. It is in cyberspace. We will never find it. So if that is the instance, you'll have to apply the provisions of Section 38. That means you will advertise in 2 consecutive newspapers, you must advertise in the Government Gazette, and then you must procure a certificate of title in terms of Section 38, which must lay open for inspection at the Office of the Registrar of Deeds for a certain period of time after the advertisements, and only then can you apply to the Registrar of Deeds for the registration of that certificate of title. Never have they asked you to prepare the advert or the application for this title deed, for this certificate of title, because it's a very lengthy process, and you cannot prepare the certificate of title unless you have the history of the previous deeds, etc. So this is a very academic question that can be asked. It has already been asked, can you apply the provisions of Section 38 if the bond of the deeds office has been lost? And the answer is categorically no. You cannot apply Section 38 to a bond. You can only apply Section 38 for the title deed relating to land. Okay, that is 38. 39.1 is an error in registration, and that is prescribed form M. Now, prescribed form M will tell you why I'm applying for it, but the background here too is the following. I have the same property, but I hold it under 2 title deeds. Now you'll tell me, Alan, how the hell is that possible? How can you hold one property under 2 different title deeds? It usually is preceded by a rectification transfer. By way of an example, and those of you that got a pen and paper, write this down. I, Alan West, go to the developer and I say, I want to buy Earth 1. And he says, Alan, this is Earth 1, transferred, Earth 1 is transferred to me. My neighbor goes to the same developer and he says, I want to buy Earth 2. And he shows it. But for some or other reason, Earth 2 is not transferred to my neighbor, but Earth 1 is also transferred to him. So now he's sitting with Earth 1, I'm sitting with Earth 1, but he is not the rightful owner. He must actually have Earth 2. Now you'll say, easy, why don't you just do a 4.1b on his title deed? Because that will have the effect of transferring a right. You can never utilize Section 4.1b of the Deeds Registries Act if it's going to have the effect of transferring a right. So what my neighbor will have to do, he'll have to transfer Earth 1 to me again in terms of a rectification transfer. Then I will be sitting with 2 title deeds. Lovely, because I can mortgage one. The deeds office will then request me immediately to take out the certificate of registered title to, I don't want to use the words consolidate, but to eradicate the 2 title deeds and make it under 1 certificate of registered title, because it will be an untenable situation to have property under 2 title deeds. Your application, once again, is as easy as falling off a chair. I, Alan West, hereby apply to the Registrar of Deeds for the issue to me of a certificate of registered title in terms of Section 39.1 in respect of this property held by that title deed and that title deed. That's it. Obviously, the developer will then, in terms of a rectification transfer, have to transfer Earth 2 to my neighbor, because he will then be without property. So this all goes with a scenario. That's 39.1. 39.2. This has also been asked in the past. I have a type. You will know that in the past, the Group Areas Act was applicable. Your certain title deeds still have derogatory conditions in it. The title deed still has your racial groupage in it. It still has an endorsement to say that this property is situated in a white group area or a colored group area, or in a Cape they had Malay group areas. And people feel aggrieved by having such derogatory aspects in their title deed, and certain conditions might have lapsed. And then, once again, not obligatory, you can apply to the Registrar of Deeds for the issue of a certificate of registered title, eradicating or removing those conditions that have lapsed by effluxion of time, that has lapsed by the legislation that has been passed, or because of certain mergers or whatever the case may be. Application, once again, not a train smash. So that is the certificate of registered title in terms of section 39.2. Guys, then we come to the certificate of consolidated title in terms of section 40. I'm putting an NB next to this. Once again, you must know how to draft the application. And once again, certificates of consolidated title have been asked quite often in the past for you to draft the application for the certificate of consolidated title, as well as the conditional clauses of the certificate of consolidated title, the extending clause thereof, and to deal with the mortgage bonds with regard to a certificate of consolidated title. Now, let us start with the application. And as I said, I was also privy to look at certain of these applications. You know what? Candidates drafted the application with all the conditions and referring to the mortgage bonds, etc., 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 in the application. Guys, the application is straightforward. And if you've got a pen and paper, write it down. Top right-hand corner, preparation clause. Heading, application. I, Alan West, identity number status, do hereby apply to the Registrar of Deeds for the issue to me of a certificate of a consolidated title in terms of section 40 of the Deeds Registries Act in respect of this earth, full property description held by that title deed, and this earth, full property description held by that title deed, which will, after consolidation, in terms of this diagram, be known as that. Sign. So all that you say, you're consolidating that property with that property in terms of that diagram, and it will now be known as this. That's all. You no conditions, nothing about mortgage bonds, nothing. So the application to draft a certificate of consolidated title should not be a problem. However, as I said, those candidates drafted it as if it was a deed, and they brought in all the conditions, and obviously what happened at the end, they couldn't finish the exam because they didn't have enough time, because they were putting in unnecessary things in your application. How do I draft my certificate of consolidated title? Now, here I'm going to give you a few tips, and I've discussed this with the registrars of deeds, and I've discussed it with the examiners. Prescribed Form O, you're going to use to draft your certificate of consolidated title. What is your what must I look out for when I draft prescribed Form O? The first thing that I have to have a not knowledge of, that I must be aware of, is who's my owner of the property. And guys, I'm sure when I tell you this, you're going to laugh now, because in the previous exams, they attached a title deed and they said, prepare the consolidated title. People don't know where to find the owner of the property in the title deed. They use the seller, the previous seller, as the owner. Now, and I know, Sipho, you're going to say to me, now, are they going to give me marks? How much marks are they going to subtract if I use the wrong owner? Yes, I can tell you, it is so frowned upon that if I give you a title and you don't know where to find the owner, how can you be a conveyancer? How can the examiners let you loose on the public if you don't know where to find an owner in a title deed? But having said that, you must know who the owner is, because that owner is going to apply to the Registrar of Deeds for a certificate of consolidated title in terms of Section 40 in respect of. Now, the entities that are consolidated, you will use the full property description without the extent. Please note this, write it down. When I do a certificate of consolidated title, I must not insert the extent in the entities that are consolidated. I will put in the title deeds, and then the property description of the consolidated property is obviously given to you on a diagram, or it will be given to you in the question. However, the extent will be in words and figures. It will be to the nearest fourth decimal figure if it's hectares. How does my extending clause read in a certificate of consolidated title? This is one of the variations to prescribed form TT, as will more fully appear from consolidated diagram SG number 1234 of 2021. Stop. Not and held by, and because it's not held by, you're consolidating. You've already said whereby the entities are held. And this is where you lose another few marks. If you're going to, you prepare your certificate of consolidated perfectly, but now your extending clause is wrong. Is the deeds office going to reject you for that? Most definitely. There is a circular. I have published that circular last week on to my group, and I've said, well, not me, the Registrar of Deeds said, any error in the extending clause will lead to a rejection. Now, is the examiner going to subtract 50% of my marks for this because I got the extending clause wrong? No, they don't do that. I think it's a harsh rejection if you're going to say held by that title, because it can just be, drawn through with a line and initialed. I don't think it's a material amendment, but that's me speaking. Now we come to what we call the conditions of the certificate of consolidated title. Now, this is where I want to give you a tip. And please bear with me now. There are certain people lecturing that say you must, when you're doing a consolidated title, you must look at commonality conditions. I say it's not necessary to look at commonality conditions. And it's not only Alan West that's saying that. I've got that from the Registrar of Deeds Pretoria, and I've got it from the Registrar of Deeds Cape Town and all the other registrars, to say that if certain conditions are common to a component and others are not, you do not have to first refer to the commonality conditions and then to the unique conditions. You can say the former of so-and-so indicated by the figure so-and-so on the consolidated diagram is subject to condition A, B, C, D, E. And then you can say the former of so-and-so indicated by the figure so-and-so on the diagram is subject to condition D, E, F, G, H. Although D and E is exactly the same in component 1 and 2, you can bring them forward under the qualification as such, because it makes it easier on future subdivisions and it doesn't confuse you. However, in your certificate of consolidated title, if certain conditions have lapsed, for instance, there are mineral rights, you're not going to bring that forward, obviously. So a certificate of consolidated title, and I want to appeal to you that if you have answered the last 5 years' papers with all the consolidated titles that have been asked, the application and the consolidated and the conditions, this exam, if there is a certificate of consolidated title, it's going to be a walk in the park for you. When we're looking at certificates of consolidated titles, we must also note on the mortgage bonds, because remember, the mortgage bonds in terms of section 34.1, 34.2, 36, 38, 39.1 and 39.2, there you don't have to lodge any consents except in terms of section 34.2 and 34.2, which makes it obligatory. But in terms of section 40, I want you, and this is important, right now NB next to this, to go and differentiate between section 40 in brackets 3, section 40 in brackets 3, and section 40 in brackets 5, small a. 40 in brackets 3 and 40 in brackets 5a. 40 in brackets 5a. When you are consolidating two entities and the same mortgage bond is registered over both of those entities, then the bondholder must consent. But his consent will be in terms of form MM. I, bondholder form MM, operative clause, do hereby consent to the consolidation of that component and that component, now known as that property via that diagram. It's a normal consent. As I said, there's no prescribed form. You use prescribed form MM for this. And the bondholder consents to the consolidation of that property and that property, now known as that property in terms of that diagram. Because now somebody, you would actually ask me, why must the bondholder consent? Because nothing's changing hands here or anything. He must know what the new property description is going to be. So he must be made aware that his former properties that were mortgaged have now changed and is now known as this. Because if he has to foreclose, and he forecloses against IRF 34 and IRF 36, it's not going to happen because those properties don't exist. 39 exists now as the consolidated property. However, section 40 in brackets 5 in brackets A says that if only one of the components is subject to a mortgage bond and the other component is not subject to that mortgage bond, meaning one property is without a mortgage bond and one property is with a mortgage bond, there is actually now more property being given to the bondholder as security than what he had before. Do you agree with me? So here we have to use form WW. I usually say 40 in brackets 3 is MM and 40 in brackets 5A. Just turn MM around and make it WW. This is when you are increasing the security under the mortgage bond now. And this will be an application and consent. But there is a form, so all that you must do is rewrite the form and know how to rewrite the form with the property, with the descriptions of the parties, etc., etc. So please take note of that. And then while I'm saying that, take note of section 40 in brackets 5 in brackets B. What does 45B, 40 in brackets 5, 40 in brackets 5B say? It says, if you're consolidating properties and the entities have different bonds over them, the bonds must be cancelled. That is what 40 in brackets 5 in brackets B says. Right. I'm going to step off consolidated titles. I'm putting an NB next to it. I don't know if it's going to come, but I won't go into the exam room if I cannot prepare the application, the consolidated with the extending clause, and how to qualify the conditions. But the qualification of the conditions, as I said, what's difficult by saying the former IRF so-and-so indicated by the figure on such and such a diagram is subject to A, B, C, D. And the former IRF so-and-so indicated by the figure so-and-so on the diagram is subject to C, D, E, F. What's difficult in that? Nothing. As I said, people do make consolidations very intricate and difficult. When you start with looking at commonalities, etc., that just confuses everybody. And conveyancing shouldn't be confusing. It should be straightforward. Right, guys, then we come to section 43. Section 43, you have to look at specifically with section 43(5)(a) as well. Because section 43 says, I cannot deal with a portion of property unless I've taken out a title for it. Now, What am I speaking about? And this is what confuses people as well. And in a very simplistic manner, if I've got a stand, if I've got an earth, or I've got a farm, and I want to sell you the remainder of the farm, I must obviously first create the remainder. And last night when I was preparing for the Zoom meeting, I said to myself, it's the same as me wanting to give you the remainder of an apple. How am I going to give you the remainder of the apple if I haven't taken out a part of that apple so that I can give you the remainder? So if I have now taken my stand and I've subdivided it into two portions, portion 1 and the remaining extent, and I want to give you the remaining extent. But in the deeds office, it is still stand 180 Waterkloof extension 30. And I want to transfer the remainder to you. I first have to take out a certificate of registered title in terms of section 43 for that portion, and then I can transfer the remainder to you. So I have to create a remainder to transfer a remainder. But if I want to transfer a portion, and this is where the majority of you guys, and I've sat in many orals where candidates sit, and we say to them, you're subdividing your property and you're going to transfer portion 1 to Mr. A. What documents must you lodge with the Registrar of Deeds? And I promise you 9 out of 10 candidates say, I will first apply for a certificate of registered title for portion 1. And then we ask, why? He says, no, but I must create the portion. The portion can be transferred directly from the mother title. The only difference between that and a conventional transfer of property is your extending clause. Your extending clause will be TT. So can you see the difference between creating a remainder and transferring a portion, and taking out the certificate of title and transferring the remainder? So this is something that you will have to digest. I don't know how to explain it more clearly to you, that section 43 is there for you to be able to deal with a defined portion of the land, or if the property is on a general plan and you want to register a mortgage bond over it, obviously you have to take out a certificate of registered title for it. If you want to register a servitude over it and it's still held under the township title, you have to take out a certificate of registered title for it. That is section 40 in brackets 5 in brackets A. I mean 43 5A. Then we come to section 42. You can draw a line through. That is the certificates of uniform title. Ladies and gentlemen, as I said, I started with conveyancing in 1972. I've never seen a certificate of uniform title. When we were updating the Deeds Registries Act, when I was still at the Office of the Chief Registrar of Deeds, I said, why don't we delete section 42 if it's fallen away by disuse? And they said, no, maybe there's still a reason for it. So, but you can ignore section 42. Then section 46. Now, many of you ask me, Alan, I see township development is a big thing. And how do I study township development for this exam? And I say to you, very easy. Because remember, every municipality now has what we call the bylaws issued in terms of SPLUMA. So the 4 provinces previously, the former 4 provinces had their ordinances which have now been repealed by SPLUMA, and section 53 is applicable, and now the bylaws are applicable. So what must I know for township development for this exam? I must know those sections of SPLUMA, specifically section 53. But once again, the SPLUMA Act is an umbrella act, but the regulations thereto are the bylaws, and they cannot ask you anything of the bylaws in the exams because they're not uniform. Coming back, Alan, what must I know for purposes of township development in the exams? I must know how to prepare, 1, an application for the opening of a township register. And if you can prepare one application, you can prepare. The application will be for the opening of the township register and for the registration of the general plan. I'm sure I've got examples in my book. You've got examples in your notes that you've got from the other lecturers. So the application for the opening of a township register should not be a problem. Furthermore, what about if I'm opening a township register now and there is a mortgage bond over the property? The bondholder must consent. Draft the consent by the bondholder. What form am I going to use for this consent? I can't find a form in the deeds registries regulation. Hereby consent to the opening of the township register and obviously the registration of the general plan and the substitution of the property for all the urban on the general plan. As easy as that. Do I know how to prepare a certificate of township title? No, because there's a prescribed form for that, and that is prescribed form V. They won't ask you that, they'll ask you the application. However, and this hasn't been asked in the past, and I'm wondering if it's not going to come. Remember, a township developer can sell the whole township or a share in the township to a new developer. How do I describe my property description if I'm selling the whole township? And what conditions, unique conditions, must be brought into that transfer where I'm transferring the whole of the township or the remainder of the township? And I want just to make you think now. Can anybody put on their mic and tell me, first of all, how is my property description going to read of the township Sun City that I have now transferred the whole of the township to a new developer? What unique conditions are going to be brought in? If I'm transferring the remainder of the township, what other additional document must I supply the Register of Deeds with? Anybody want to take a chance, answer the question now and not make the same mistake in the exams? Anybody? Anybody want to take a chance, or do you want me to tell you? Somebody looking up in their books or their notes? I hope you're still there, guys. Andries, is everybody still there? Andries also gone.
Yes, I'm here.
We're here. Why is nobody speaking to me, Andries? Anybody? I'll repeat the question. I'm transferring, let's just say I'm transferring the remainder of a township to a new developer. How would my property description read in my new deed of transfer? What unique condition must I bring forward into my title deed? And what other supporting document must I lodge with the Register of Deeds? Anybody? Okay, I can see this. If this is going to be asked in the exams, you're going to have a problem. So your property description is going to be the farm so-and-so, now known as the township Sun City, registration division province, measuring so-and-so. Now the measuring so-and-so, you now have to give the Register of Deeds what we call a certificate of remaining extent. And this is all set out in section 47 of the Deeds Registries Act. So you have to study section 46 and section 47 together. Then you'll see section 47C says the following condition must also be included in the title deed, that this property also includes all parks, streets, public places, etc. So guys, do yourself a favor, go study the provisions with regard to the transfer of the remainder of a township or a whole township or a share in the township, specifically the description of the property, the extent of the property, the certificate of remaining extent, as well as the additional condition. Right, That is certificates of title. Guys, and once again, I say important, important, important. There is going to be a question on certificates of title. They won't not ask you anything about certificates of title because it forms a huge part of our syllabus, okay? Right, certificates of title. I don't want to go away now and do something else if you have a burning question on certificates of title. Anybody want to ask me a question on certificates of title? Can we continue? Sectional titles. Guys, what makes sectional titles so easy in the exams is that for everything except, there's always a except, there's a prescribed form. So what am I saying? And I want to take you through the provisions of the Sectional Title Act. Remember, the Sectional Title Act has now been actually watered down a hell of a lot because there is the Sectional Title Management Act that came into operation in 2016, which has taken out all the management aspects from the Sectional Title Act and put it into the Sectional Title Management Act. Sectional Title Schemes Management Act, and then there's the CSOS Act as well, the Community Schemes Ombud Services Act, which obviously has a different application. However, you have to know certain definitions. So I'm going to start with Section 1, and I'm going to say to you, it is important that I know certain of the definitions. And I think it was about 6 exams ago, and you'll find this funny if I tell you, but the question was, differentiate between a section and a unit in a sectional title scheme. The answers that we got is, a section is a flat with furniture, sorry, a section is a flat without furniture, and a unit is a flat without furniture, or other way around. I say once again to candidates, if you really don't know the answer, don't open yourself to something like that, because a legally qualified person doesn't write things like that. There was a question as well, and this would sound perhaps very crude, but the question was, explain what is a usufruct. And the guy said, it is the right to use something to the exclusion of, I can't even remember the answers, but the answers were so distant and so far from the real, what is the difference between a usufruct and a habitatio, and those are aspects of our conveyancing that is important because you have to know it. In the last question paper they asked, what is a fideicomissum residue? And I very much doubt if anybody knew what a fideicomissum residue is. And then I wonder, do you know what a fideicomissum is? So these are aspects that forms part of our conveyancing, and we have to know it. But I'm preaching again. I don't want to preach. First of all, Section 1 gives us certain definitions. I have to know the definition of a section, a unit, common property, participation quota, and then the definition of a unanimous resolution and a special resolution. 6 definitions that I want you to be able to express in your own words or in the words of the Act. Section, unit, participation quota, exclusive use area, special resolution, unanimous resolution. So that is Section 1. Section 4, please note on the provisions of Section 4, when, or the question actually, because it's academic, do I need to consolidate properties if I want to open a register on 2 or more properties? And the answer is yes, and the answer is no. Previously, under the old 1976 Sectional Title Act, you could not open on more than 1 property unless you consolidated it. This Act says you can open it, provided if the sections are going to be on the different properties, then you have to notarially tie it. So look at the difference between consolidation and notarial tying. Look at the provisions of section 4. So now we've looked at section 1, we've looked at section 4. 5, 6, 7, 8, 9, 10. Important that you read section 10 in conjunction with your affidavit that you're going to give in terms of section 15B3C. This is the instance when the developer is selling property of which he opened a sectional title register. Remember, if he's selling property, if he's selling a section in a sectional title scheme and there were lessees in that scheme, they have what we call a statutory preemptive right. And they have to exercise that right within certain periods of time as set out in terms of section 4. However, if there were no lessees, he has to give an affidavit to say that the provisions of section 10 is not applicable. If it was applicable, that it was, section 10 is applicable and that it has been complied with. So read section 10 in conjunction with section 15B3C. They've never asked you, never in any exam paper, asked you to prepare a certificate, affidavit in terms of section 15B3C, and they've never asked you to prepare a conveyancer certificate in terms of section 15B3. So, and I've always wondered why. Look, they're always looking for new questions, eh? So note on that. Section 11 is your opening of your sectional title register. Now, guys, the application for the opening of the sectional title register, there's a prescribed form. You must know which prescribed form you're going to use. It is obviously prescribed form B, and then for the issuing of the certificates of real rights and certificates of exclusive use areas, rights of extension, and for the units, it is B, at C, F, and G. You've got those forms. However, note, and this is where I'm appealing to you, there to most of those prescribed forms, there are footnotes. Read those footnotes. I see the candidates, if you ask them to prepare the application for the opening of the sectional title register and you give them a set of facts, they just write that whole prescribed form B, not taking cognizance that there might not be real rights of a real right of extension. There might not be exclusive use areas. Then you cannot apply to the Registrar of Deeds for the issuing of those real right title deeds. So please note on section 11, the documents that must be lodged at the Registrar of Deeds for the opening of the sectional title register, as well as if there is a real right of extension, those documents that must be lodged. So that is, now we've said definitions, section 4, section 10, section 11, the opening of the sectional title register. I said to you, for everything there is prescribed forms except the 15B3 certificate, this affidavit that we just referred to in terms of section 15B3C, and what we call the 11.3B schedule of conditions. In the last exam, they asked the 11.3B schedule of conditions again. And if you, because they have to give you the conditions, but there's other unique things that have to be brought into your 11.3B schedule of conditions, and that is contained in regulation 10.2 of your Sectional Title Act. So you've got your Sectional Title Act in front of you. If you know that your 11.3B schedule of conditions contains a certificate by the conveyancer saying what conditions the property is subject to, and if he's reserving a real right of extension, the period, and exclusive use areas, which exclusive use areas, and then 10.2G tells you what must be brought in your preamble of your 11.3B schedule of conditions. So now we've got a bit of background. We opened the register and we're now going to transfer the first section. Once again, if I'm going to transfer a section in a sectional title scheme for the first time from the developer, there are certain unique documents that must be lodged. And I've just mentioned one now. However, prescribed Form H you're going to use, as I said, the property descriptions are in prescribed Form H. You do not have to memorize that. The unique documents over and above, the power of attorney, the transfer duty receipt, the rates clearance certificate for the land, as well as the section, if the body corporate is coming into existence now, as well as the 15B3C, the 15B3 certificate and the 15B3C certificate, as well as the form that you use for the coming into existence of the body corporate, which must now be lodged in triplicate, which will be lodged in a separate cover. So what I'm asking you to be able to do is, if you're going to transfer a section for the first time from the developer, what unique documents will be lodged, and you will have to be able to prepare the 15B3 certificate and the 15B3C certificate. And know that the coming into operation of the body corporate, there's that form that you use, Form W, and that is lodged in triplicate. Then we come to subdivision, consolidation, and extensions of sections. Form O. I cannot explain this to you. I, in my book, have tried to give you the section, the application that you're going to do, and if there's a title that must be issued, the title deed that must be issued. So Section 24 has often been asked in the past. So I would, once again, if I am preparing for this exam, I will spot Section 24. The extension of a scheme, Section 25. You've got the Act in front of you. Look at the provisions of the whole of Section 25 and spot that for the exams. Then I want you to look at Section 34. Remember when we were doing townships, I said, can I transfer the whole of a township or the remainder of a township or a share in the township? Yes. Section 34 says I can transfer all my right, title, and interest in a scheme as the developer, or a share thereof, or the remainder thereof. So look at Section 34 and the uniqueness of doing it in terms of prescribed Form H, but how to draft your prescribed Form H when you're transferring the whole of a scheme or a share in the scheme. Sectional mortgage bonds. What can they ask you under sectional mortgage bonds? Ladies and gentlemen, very little, except, which they love asking, and it might come now in this exam. What's the difference between a sectional title mortgage bond and a conventional bond? The one has a prescribed form, the other one doesn't. The one is executed before the conveyancer, the other one is executed by the Registrar of Deeds. The one has an annexure of conditions, the other one doesn't. The one is mortgaging a section or an exclusive use area, and the other one is mortgaging conventional property. So those are the unique. And as I said, your prescribed forms are Z, AJ, and AK. AJ and AK is for the collateral sectional mortgage bond or the mortgage bond for surety. The Sectional Title Management Act. Must I study the Sectional Title Management Act? They have actually only said you must study a few of those sections. Section 2, obviously, you must have a working knowledge of when does the body corporate come into existence. How do you describe the body corporate? What are the functions of the body corporate? Specifically, how to create rules in terms of the Sectional Title Management Act that must be registered with the Ombud. Look specifically at Section 10 in bracket 7. And then I appeal to you to look at Chief Registrar Circular 13 of 2016. 13 of 2016, which actually summarizes the Sectional Title Schemes Management Act. Conversion of share blocks into sectional titles. Ladies and gentlemen, I'm not going to elaborate on that. The only uniqueness there lies in the causa and the 15B3 certificate that is set out in my book. Statements of an account. Do I need to prepare a statement of an account? Most definitely I need to prepare a statement of an account. Candidates must be capable of preparing the statement of account to be handed to any party for whom a transaction is done. And Anton will tell you, even if you ask him, that it's not necessary for you to spend not all your time, a major part of your time trying to balance your statement of an account. As long as you've got your debits and your credits correctly, then you shouldn't have a problem. If the question is for 30 marks and you haven't balanced it at the bottom so that it balances, you might lose an extra 2 marks. They don't penalize you for that. So I would not spend my time trying to balance. I would just get my debits and my credits correct. Now, yes, Anton will also tell you that they give marks for correct debits and they give marks for correct credits. However, one very clever candidate thought, I'm not sure what is a debit and what is a credit, so he put all the debits in and all the credits in. Now, you couldn't now give him any marks, could you? Because he didn't differentiate. He just put all the debits in the debit column and all the credits in the credit column. Not all the credits and debits, all the amounts in the debit column and in the credit. He got naught for that exam paper. So statement of an account, yes, to the transferee and the transferor, and maybe to the mortgagee and the mortgagor. So please look at that. Chief Registrar Circulars, I'm not going to elaborate on that. I've already said that there are certain Chief Registrar Circulars that you must have a good working knowledge of. I specifically referred you to 5 of 1994, description of parties. Once again, 27 of 2013, when we come to customary marriages. 1 of 2007, when we come to civil partnerships. 28 of 2013, when we come to companies. And so I can continue, but those circulars have been sent to you, so you should be able to go through them. Registrar's Conference resolutions. Now, at this point in time, I still have certain of Audrey's candidates phoning me and WhatsApping me and emailing me and say, please, I need that conference book of yours, and because I must prepare for the exams. Guys, if you want that book now and you want to prepare now for the exams, you've lost it. Because let me just show you how thick that book is. I don't know if you, this is how thick the book is. It consists of 1,233 pages and another, okay, it consists of 1,311 pages. So if you think you can even page through that before the exam, it's not going to happen. I'm asking you to look at the last 4-5 years conference resolutions. That's it. Don't go back to 1938. That's not necessary for this exam. That practice has already been established. And I think I really don't think examiners go to the 1965 conference resolutions and look for questions there. They look at the latest conference resolutions. Candidates must be conversant with the guarantees that must be issued under the different circumstances. If you just look at the last exam paper and the memorandum to the last exam paper that was asked, I think in the first paper, the certain guarantees that must be issued, I think that will suffice for purposes of this exam. Guys, then we come to questions and answers. I'm now going to ask Anton to join us so that he can ask a few questions. And after that, I just want to concentrate on a few of the acts that I think it's not necessary for you to study. So I'm just going to, give me a second, I'm just going to try and get hold of Anton quickly. Andries, you can still see me? Andries, can you still see me?
We can still see you, Mr. West.
You can see me. I'm just going to call Anton quickly. Ladies and gentlemen, Anton is on his way. Is there any questions that you want to ask me before he comes, or are we going to leave that till after he has completed his talk with you? As I said, I would like you, after Anton has spoken to you, I want us to go through the syllabus, because remember the syllabus, paper 1 is the acts, but don't think that paper 1 is only the acts. It also covers description of parties. It can also include extending clauses, because that is in the Deeds Registries Act. But I'll do that with you as soon as Anton has discussed the aspects with you. Please, you're more than welcome to put on your mic and ask him questions. Anton, thank you very much for taking the time to be with us.
It's a pleasure, Alan. Good day, candidates. I hope you are all very well. And I assume after this session, you will know everything that there is to know about conveyancing. It's very difficult for me to discuss the exam with you without knowing what kind of problems you have. I think I did mention to you in the beginning that everything that is mentioned in the syllabus is important. And everything that is mentioned in the syllabus, questions can be asked regarding all of those acts. For the first paper, it's of particular importance to ensure that you know every single section that has been highlighted in that syllabus of each and every act. Nothing is unimportant, and questions can be posed on any of those aspects. What I found with the last exam is the candidates seem to have disregarded the NHBRC and the legislation that's associated with that because they deemed it not to be important. But obviously, if you look at the case law, as I've said before, all those aspects are being dealt with in facts relating to the problems that arise from those acts. So please, I have to urge you again, particularly for the first paper, make sure that you have had a look at each and every one of those sections mentioned. It's a good practice to look back as far as possible in the conference resolutions, because that's now the registrar's conference resolutions, because obviously those are the kind of problems that we face with daily in the practice, and it makes good material for asking questions. So make sure that you know that. I would say look back at least the very minimum 5 years. The papers, the previous papers, I've got my own ideas about that. I think it is a tool to equip you to be able to do the exam, but it's not the primary tool. What you should know is the syllabus and the acts and the aspects that are mentioned in the syllabus. So at this point in time, I'm going to hand over to you, and you can ask me questions, and I'll answer it as frankly and openly as possible. Alan, is there anything that I have to do when they ask questions? Or
no, they will put on their mic and they will ask you a question. And I'm sure there's a lot of them that have the burning questions, so they'll put on their mic.
Doesn't seem like it, Alan.
Well, that's good news if they got no questions. Anton, I thought that they would ask you what's in the exam paper.
The syllabus. Yes, I can. Is it Nicolene?
Yes, Anton. I just wanted to know, so you talk about the acts for the first question. So I know in the syllabus it states there that we don't have to obviously know the forms off by heart. So we won't get asked like something on the forms in the first paper then, like relating to the forms basically.
Well, I don't know. I can't recall that they actually say that you can't be asked, but it would be highly unlikely that you would have long questions, drafting questions in the first paper. Well, let's put it to you this way. I can categorically say that you won't have any long questions that entail drafting, because the forms usually is utilized in the second paper where you have to do the drafting and drawing. So I'm not going to, or the examiners won't pose a question on the forms itself, but the forms are just, let's call it a regurgitation of what the Act says. If you look at the forms, they actually mention the Act and the regulations. So in that sense, there may be questions, but it won't be what does Form O or what does Form this or that say. Does that answer your question, Nicolene?
Yes, it does. Thank you. And then I also wanted to know with transfer duty, in respect of transfer duty, I know, so obviously with the latest tariff, that's all we need to know. We don't need to know any previous year tariffs. Is that correct?
Correct. We shy away from asking questions that are relating to historical transfer duty, because it's not necessary to know it off by heart, you know. So, but beware that you do know the current.
Okay. And then also with transfer duty, when it comes to like working out transfer duty and working out like where there's a half share or a 1/8 share or something of a section title, in terms of that, do you get like part marks, or is it the whole thing has to be correct?
Well, you know, they usually say in the question itself whether you have to show your calculations. Now, obviously, if you have to show your calculations and you show that you know the tariff or the applicable way of calculating, and you make the error in the bottom line, if I may call it that, you will get marks for as you carry on. But you must look at the marks that are allocated in questions like that. I mean, if it's for 2 marks, you usually will only have to put the answer. But if it's more marks, then obviously the calculation you can see will form part of the marks allocated for the question. So to answer your question in short, you will get marks if you show the calculation to be correct, but you just make a mistake in the final. But normally, if you have your calculations correct, you will have your final amount correct as well, because you are allowed to take calculators in.
Okay, thank you.
Pleasure.
Sorry, I just want to ask a follow-up question of Nicolene. So let's say I run out of time and I have one transfer question left and I just give the answer because I have no time to write down. If your answer is correct, you should get all your full marks.
Yeah, you know, once again, I think if the question normally says what is the transfer duty and show your calculation. So then you won't get marks for if you don't show your calculation. You'll get the mark for the answer, but you won't get the calculation portion of it.
Okay, I see. Thank you, Mr. Then the other question I had is just regarding this one issue of the Muslim rights. I know last year they asked a question regarding the Muslim rights and whether, and in the memo it said that a marriage is not recognized in terms of Muslim rights. But I'm sure that memo is not correct anymore after the court case. So then we'll say, you most likely won't ask us a long question on this, but we'll basically have to just be able to state that it is recognized and how to describe the parties, if I'm correct.
Well, that's normally what we want to know is do you realize that there's been a change and that that's not right to describe them as unmarried any longer, you know? So yeah, I think you answer your own question.
Okay, because I know that question specifically stated that whether the imam was registered or not registered, and I read through the case and I might have missed it, but I don't see specifically where it was dealt with that if he's registered or not registered. But But at the end of the day, we just have to know that it's recognized.
But I think Alan dealt with it extensively during the course of what is now regulated. Alan, am I right?
I want to touch on it again because I see there's still confusion between this case that's going to the Constitutional Court and with regard to imams that have been registered. And then the marriage is not in terms of Muslim rights, it's then in terms of our in terms of the Marriage Act of 1961. Correct. But I'll touch on that again.
Yeah. Okay, Alan will deal with you extensively again on that, because that's important that you know that difference. Okay.
Okay, thanks, Mr. Theron.
Right. Anybody else? And then it seems like they've run out of questions.
I can't believe it, Anton, because they said to me they've got so many questions. Can you just give them a bit of guidelines as well? Because I touched on the statement of the account, and just tell them where they go wrong with the statement of an account, please.
Yeah, you know what? The statement of account is a controversial. That should be a sitter for you, because you get marks for your showing your method. But oddly enough, we find that the attorneys or the candidates are very bad at doing bookkeeping. They get their credits and their debits wrong. So make sure that you know at least what the columns are and what must go where. And it really, if you do get and I'm not saying there is one, if you do get a calculation or a account, it should be actually that you say thank you, because it's easy marks. We don't. If your bottom line again is wrong, you get allocated, or a certain amount of marks will be forfeited. But if you have your other entries correct, you obviously get marks for each one of them. So, and generally, I mean, if you look at the accounts, they are basic, straightforward. What usually is a bit of a difficult situation, as we find for the candidates, is if they say you have to calculate the levies and the rates and taxes, if you have to apportion it. But those things have been asked over and over and over again over the years. And if you've looked at a few accounts, you shouldn't have any problem with that. I think that does answer your question, that the accounts shouldn't be difficult. Anything else?
Maybe this year, is it possible? I don't know, what is the move to now in terms of the long-winded questions that seem to be wasting time for people? Any move towards cutting the questions to shorter questions, because I'm told that it eats a lot of their time.
Zukile, yes, I think there's a conscious effort to ask shorter questions, but I mean, in some cases, just to formulate the question would take a couple of paragraphs. Now, I don't recall that there were any questions in this one which has long-winded factual paragraphs or necessity for long-winded questions. But it is by the very nature of conveyancing, if you have to ask a question posed upon a factual situation, just like a court case, it may be necessary to ask a bit more, because otherwise you can't ask the question properly. But to answer you in short, there is an effort to make the questions shorter.
Thanks.
I can tell you in the first paper, there's no long-winded questions. Anybody else?
Anton, thank you so much. I don't think if there is, I'm going to give them the opportunity to send me an email or two, and we can obviously address it.
Of course, and then you can answer them. Okay. Yes. Okay, good luck, everybody.
I can't believe that you wasted your time like that, guys. You could have asked him questions that's going to be in the exam paper. My word, but okay. I'm being facetious. Guys, I just also want to say to you, please, the notes that you are using, please ensure that they are the updated notes. And I know people are handing down Mr. Gawie Leroux's notes, etc. A candidate phoned me last night. Now, I hope he's not one of these candidates. He said, Alan, I've got your book called Articles on Conveyancing Practice for Attorneys. And I'm using that for the exams. Guys, I just took it out because it's in my library here. That book is a 1995 book. If you're studying that book for the exams, you're going to come very short because the practice has changed so dramatically since 1995. That is how many years? 26 years ago. You can't use this book for the exam. I hope that you've got the updated, and this is actually where candidates are going wrong, because they say, but I studied and it's in the notes, and now I can't understand that I got it wrong, because the acts have changed, the legislation has changed, the acts have been updated, new forms have been procured, etc., etc. So please just ensure that you've got updated notes. If you've got Gawie Leroux's notes, let it be the 2020 notes or the 2021 notes, because he updates his notes on a yearly basis. I just want to say that. Are there any questions from your side that before I go through the syllabus with you quickly?
Mr. West, I just have one question quickly.
With
regard to our power of attorney, when we're drafting our power of attorney for each situation, I made a note here previously that said we don't have to include the divesting clause. Is that correct?
Not a divesting clause. You do not have to include that general condition clause.
No, that's what
you will stop after held by deed of transfer signed at Pretoria. You won't put in that. And I think Anton said that in his first session to you. You're wasting time if you're going to put that in. It is not necessary. So you will stop after the property description and the new condition, or whatever the case may be.
Okay, and then signed after the conditions, basically.
Exactly.
So much.
Because I know, you know, that clause, to tell you the truth, I wouldn't even be able to rewrite that clause out of memory now. So, and it can't be expected from you, and it's a waste of time in any case.
Yes, I agree. Thanks.
Okay. Anything else, guys?
I have a West.
Yes.
It's not really like, I don't know how relevant this is. I just want to know how many people actually finish the whole paper from start to end.
It's a pity that you didn't ask that to Anton. Well, in the last 2 exam papers, the majority of people completed it. Anton, what he does, he answers the question paper in longhand and answers it, and if he sees that he cannot answer it at least in a 3/4 of the time, the paper gets shortened. So I cannot categorically tell you that 90% finish it within time. We have candidates that say, you know, I have a writing problem, etc., etc. And I've seen papers myself that sometimes it is totally, in the beginning you write very neatly, and then it is just an absolute scribble towards the end. However, they're not looking at how neat your paper is the content there. So yes, don't try and print and write the longhand, do what you have to, but yes, I can say this paper you will have sufficient time. Let me just put it categorically, Nicoline, you will have sufficient time.
Okay, thank you.
Provided you don't draft unnecessary documents.
Yes. And I remember you did say we can answer it in any order. We don't have to go from question 1.
I say take your red cokie, your orange cokie and your green cokie. Mark the questions that you can answer perfectly with green, then your orange, then your red. So you can answer them in any sequence whatsoever.
All right.
Even with your short questions. Because don't sit on a question and sit and ponder and ponder and ponder, because that makes you totally, it puts you in a different mindset, and then you can't answer you get a blank.
Okay.
So you've got your 15 minutes before the time that they give you to read through that paper. While you read through it, and you can make notes on the paper itself and say, this is a section 24(6) application. This is a section 34. This is this. This is this. So there you can already write so that you, when you get to that question, and you know, you've already got a few guidelines there.
Thank you.
When are you doing away with this so-called open book test?
Are they going to do away with it?
Take out those legislations, and just people must ask questions, must answer their questions like other exams. I mean, I think it would make things easier for me than having this hopeful, you know, all these books around you. I mean, I think then, you know.
Zukile, it's not books around you. It's only this little book that you've got in front of you, and this is only the Deeds Registries Act and the Sectional Title Act. But if you can write the exam without this, which, look, I did my conveyancing exam in 1984. We had to memorize all the prescribed forms, which I think is unfair. And that's why they said, yeah, you don't have to memorize a prescribed form. Yeah, we'll give you the forms. And they've given you the forms now, which makes it a bit easy. So, and I think the perception that it's an open book is the wrong perception, because it's not an open book. Anton, and it's a pity you didn't ask him, he lobbied that, so you can bring as much books as you want to into the exam room. But that is going to cause chaos, because, you know, what are you going to bring in? How is it going to be monitored? We'll have to provide it to you. So that's not going to happen. So that is why they give you the deeds. So Zukile, I think it's just a aid. But if you can do without it, most wonderful. Let me just get back to Muslim marriages. Guys, the latest court case that was issued in the beginning of this year now says that Muslim marriages in terms of Islamic rights, meaning that it is still a marriage that was concluded in terms of religious rights, is now recognized. But the consequences thereof has not been sorted at this point in time. They gave the Department of Justice 2 years to come up with the act. In actual fact, when I saw this court case, I was privy to the drafting of the first recognition of the Muslim Marriages Act. And you know what that was? That was in 1994. I've got the draft act on my computer. However, there was much controversy around that, because who's going to affect the divorce? Long story short, they are working on the legislation. However, a marriage concluded in terms of Muslim rights is now recognized. But it is not recognized as in community of property or out of community of property. It is recognized and it is governed by Muslim rights. What the effect thereof is going to be brought into legislation. However, we know that in 2014, certain imams, not all, were ordained as marriage officers. And if they solemnize a marriage between two Muslim parties, that marriage is governed in terms of the Marriage Act of 1961. And those parties are then married in community of property, or they must enter into an antenuptial contract to make their marriage out of community of property. So then there's no difference between that Muslim marriage and any other heterosexual marriage in terms of the Marriage Act of 1961. But now, you won't believe it, and I can show this to you. How many emails I just received. I don't know if she's here today listening to me, but she says to me, her parties got married in India while the husband was domiciled in India, and they entered into a Muslim marriage. They're now in South Africa and they're buying property. How do we describe them? Now, if the husband was domiciled in India And India recognized that marriage. That marriage is governed by the laws of India. So it will be A, identity number, married, which marriage is governed by the laws of India. You cannot now say married in terms of Muslim rights, because it's not Muslim rights, it is the laws that govern that marriage in terms of India if it was domiciled there. If he was domiciled in South Africa, it will be married in terms of Muslim rights or Islamic rights, how you want to express it. So there's nothing strange about this. But people confuse the imam that has ordained the marriage who's not a marriage officer, then it's Muslim rights. And as the judge, the court case said, it is at the best a marriage out of community of property. At the best, a marriage out of community of property. But you don't describe them as out of community of property. The same now with the court case with regard to customary marriages, where the latest court case said, and I don't agree with it. Now I'm waiting now for the Constitutional Court to look at it. But they said, if I enter into, let me call it a black marriage, a customary marriage, and thereafter I decide in terms of 10, it's section 10 of the Recognition of Customary Marriages Act, to, I don't know how to express it, but to conclude a civil marriage with the same party. What are my matrimonial consequences now? I was of the opinion, and I told you that I was very involved with this act right from the beginning, together with Professor Thandabantu Neshlapu. We did a roadshow on this, and he was at the Law Commission. He drafted this legislation, and he knew what the intention of the legislator was. Now, the intention of the legislator with Section 10 was just a confirmation of a customary marriage into a civil marriage. He called it a one-way street. You cannot go the other way. You can only go from a customary marriage, an open-ended marriage, into a restricted marriage, into a civil marriage. However, that marriage will stay in community of property if you haven't entered into an antenuptial contract. But now the judge in the latest court case said, no. And he said it as an arbiter. He said, if I convert my customary marriage into a white marriage or a civil marriage in terms of the 1960, then my matrimonial property regime will be in community of property until I enter into the civil marriage, then it will be out of community of property. Now, guys, can you just imagine the consequences? If I come to you now and you ask me, how are you married, Alan? And I say, up until 2019, I was in community of property. Thereafter, I'm now out of community of property. Here's my antenuptial contract. But I bought the property in 2017. Must my wife now consent? Is it the asset in a joint estate? Ladies and gentlemen, this is going to cause absolute mayhem, specifically on divorce, on etc. That is why the legislator said that if you want to change your matrimonial property regime after you concluded the civil marriage in terms of Section 10, you have to do it in terms of Section 20 or 21 of the Matrimonial Property Act by virtue of an order of court. But that is all academic, and they won't be asking that type of academic question in the exams, okay? Any other questions, guys?
I was just wondering with regard to the conveyancing update that you gave.
Did you listen to me?
Yes, I did listen to you.
Okay.
Is there anything else that you think might also be of importance that might show up in our exam, like, for example, with the Muslim marriages?
No, because it's very controversial at this point in time. Remember, the conveyancing update was for conveyances to bring them on par with the latest court cases and the conference resolutions and chief registrar circulars and new legislation. They can't ask you anything about new legislation in this exam, obviously, and that was part of the conveyancing update. But the new conference resolutions, I think Anton mentioned that. He said, beware, where will I find questions short questions for this exam. I look at my conference resolutions. So, and there was only 7 conference resolutions taken in 2020. But look at them. There was only, I think, 14 taken in 2019. Look at them. And then 2017, 2000. But take the last 5 years conference resolutions and look at that.
Okay, thank you so much.
Can I ask a question on sectional title?
Yes, please.
Section 25, reservation of a right for extension.
Yes.
Has to be for a determined period.
Yes.
There was a question, what happens if there's a mistake made and no period is mentioned? So in other words, it's indeterminate. How does that get rectified, or what are the consequences?
Very good question. You know why they asked that? There was a conference resolution on it. And they said it can be rectified in terms of section 41B. Or it can be done by virtue of a bilateral notarial deed. So John, just go back to your conference resolutions, and there's an index in this conference resolutions. And if you look at section 11.3B or the time period, you will find the conference resolution. Do yourself a favor. I don't want to give you the full answer now, but that type of question they've got from the conference resolutions. And that's why I'm appealing to you to go and look at the conference resolutions. And I hope Anton is not listening to me. I saw him paging through the conference resolutions this last week. So, yeah.
On those resolutions, I believe that they meet every year. It gives offices heads.
Correct.
But
So, Kili, they meet every year between October and November. I was at that conference from 1984 up until 2014, every year. And we went to the most extravagant places. And we worked hard, but it was wonderful to sit there and vent all our problems that we have and then come to resolutions. A guy, I don't know if you know, Mr. John Christie. He was part of the panel for the conference resolutions. He passed away last night. So our condolences to him and his wife. He's been with the conference for many years. He was a conveyancer in Pietermaritzburg, and very well respected. He also wrote the book on conveyancing, the shorter version of my book as well. So yeah, I just want to say our condolences go to him and his family. And you know, I never forget, after the conference one day, he said to me, he phoned me and he said to me, Alan, your voice still rings in my ear about this one conference resolution. And you know what it was? I was very adamant that mortgage is the first step to alienation. And all those conference resolutions, I think there was about 12 conference resolutions taken, was now repealed by a law advisor opinion. But yeah, he was very adamant at those conference resolutions that I was wrong, and rest his soul, I was wrong, and I concede that I was wrong.
Yes, I wanted to ask, I mean, on average, how many of these resolutions you pass? I mean, why every year there's new things?
Because there's new practice.
Okay.
Remember, Zukili, I just want to say the resolutions are there to create uniformity. We've got 11 deeds registries, and if every registrar of deeds is going to have his own opinion on the interpretation and practice and procedure, then it's going to be, then you as a conveyancer would not know what to do. So for that reason, the registrars say, let us meet and then let us create uniformity. And this is made public to all the conveyancers, so that I know that if I get a bond that has been lost, can I use section 38 or must I go to court? So there's always new, and that is why conveyancing is not something that is stagnant. It continually, there's changes in practice, there's new legislation, there's new sections, and many of those conference resolutions convert to an amendment of the Act. So that is the reason why there's a conference every year. Okay, guys, I just want to go through a few sections or statutes with you. Now, if you've got the statutes in front of you, the Administration of Estates Act, I want to say to you that Section 80 is one of the most important sections in the Administration of Estates Act, over and above 42.1 and 42.2, but concentrate on Section 80. The Advertising on Roads and Ribbons Development Act, there I want you to specifically look at the cancellation of conditions in terms of Section 11, 8 and 9. And now know that there was a court case that said that the controlling authority is now no longer it was a board or whatever the case may be. It is now being delegated down to the municipality. The Agricultural Holdings Act. You will not be asked any questions on the Agricultural Holdings Act in the exams because that act is only relevant to the old Transvaal. So draw a line through that act. Don't look at it. The Alienation of Land Act. I think we went through that the first day or the first session that I had with you. Put an NB next to that act, and I already highlighted which sections are important. The Birth Deaths Registration Act, Section 23 to 26, specifically, and you must read that act together with Section 93 of the Deeds Registries Act. Here we're referring to the change of name, change of surname, etc. of persons, and whether let us look at Muslim marriages now. Can a Muslim wife assume a husband's name? Yes. Can a customary marriage assume? Yes. And as I said, a wife can assume her name at will, and she can revert at will. So look at sections 23 to 26. The Black Communities Development Act. I will not study that for the exams. The Children's Act. Look specifically at Section 18. The Civil Union Act. Look at the definitions in your Civil Union Act, but study that act. Study that act in line with the Chief Registrar's Circular, and I think it's one of 2007. So that circular on the Civil Union Act tells you everything that you have to know about civil unions. The Close Corporation Act, we know that that has now been repealed. The only thing that still exists is that you can convert a close corporation into a company. But that you study in conjunction with Chief Registrar Circular 28 of 2013. The Collective Schemes Control Act. Can you remember when we did participation mortgage bonds? I said participation mortgage bonds gets governed by the Collective Schemes Control Act. And I said, don't study the act, study the circular, because the circular tells you what Section 1, Section 40, Section 46, and Section 52 says. The Companies Act, hallelujah now that they have given us a breakdown of which sections. Remember previously they said the whole Companies Act, which consists of 287 sections. They've now broken it down. Those of you that have Javi Leroux's notes, he's got a beautiful, very comprehensive note on how the Companies Act affects a conveyancer. Try and get that. I'm sure most of you have it. If you haven't got it, try and get hold of that, because that answers all your questions. Somebody asked me, they asked something about the Turquant rule in the last exam. That's all set out in if you look at the provisions of Section 19 and 20 of your Companies Act. That governs the Turquant rule, and it speaks about the Turquant rule. So it's not something archaic, it is relevant. The Community Schemes Ombud Act, there they've given you a few sections, and you will see that that question, one of those questions was asked in the last exam paper as well. The Constitution of the Republic of South Africa. Now, guys, I believe that that is the most important piece of legislation that we can have in the Republic of South Africa, but for this exam, I'm going to say to you, it's not necessary to study it. The donation tax imposed in terms of the Income Tax Act 58 of 1962, there you have to know what the rate of the donation tax is and how the exemptions apply. Please go and look at the exemptions and the rates. The Expropriation Act. I will not study the Expropriation Act. I said to you, I will study Section 31 together with prescribed Form G for purposes of the Expropriation Act. The Financial Intelligence Act, very important that you know to whom that act applies. How do you FICA certain persons? And that is, I think, important as well. Formalities in respect of leases of land. It says the entire act. Guys, it contains one section, only one section. And the crux thereof is, hier gaat voorkoop. So whether the rule of knowledge applies, 10 years or longer, must it be registered? If it's not registered, what is the effect of that act on lease agreements? The Housing Consumer Protection Act, there was a very important case on that, and that specifically on Section 13. And that question was asked in the last exam paper. So I will once again go look at Section 13 and study it in conjunction with the latest court case. The Movable Property Removal and Modifications of Restrictions Act, there I refer you to Section 6. And that section specifically refers to successive fideicommissums, that it's only valid up until the second set of fideicommissary heirs. So look at Section 6 there. The Immigration Act, very important, specifically for conveyances, because there's a penalty for you, the conveyancer therein, if you're going to make property available to an illegal foreigner in the Republic of South Africa. So there, Section 1 gives you the definitions, and Section 42 and 49 tells you how to apply the provisions to foreigners and illegal foreigners. The Income Tax Act, there, very important, Section 35, capital A. And the latest rates there, 7.5%, 10% and 15%. Look at that for purposes of this exam. The Insolvency Act, we've done the Insolvency Act when we did transfers in terms of insolvency, very important. Interstate Succession Act, I'm putting an NB next to that. You must know how to administer a estate where the person has died insolvent, not insolvent, where he's died interstate, and what supporting documents must be lodged with the Registrar of Deeds. The Land Survey Act, I'm not going to study that for the exams. The Matrimonial Property Act, important, important, important. Look at Section 1 and look at Section 15. Specifically Section 15, the exemptions and the latest case law on Section 15 as well. The Recognition of Customary Marriages Act, important, important. Study it in conjunction with Chief Registrar Circular 27 of 2013. The Sectional Title Management Act, there's only 20 sections in it. Most of it speaks about the powers and functions and duties of the trustees and the body corporate, etc., which is management act aspects. Just an overview of that act should be sufficient. The Spatial Planning and Land Use Management Act 16 of 2013, it has been given to you there. I think that Section 53 is very important there. As I've already told you that I cannot ask you anything about the bylaws. The Subdivision of Agricultural Land Act 70 of 70, very important. And now I'm specifically looking at the definition of agricultural land. We're looking at Section 2, the exemptions, Section 3, the transactions which needs the consent, Section 6, capital A, the servitudes that are exempt. Please study that very well. High Court Rule 63 and the Hague Convention, NB. Transfer Duty Act, we've covered that. Trust Property Control Act, Section 1, Section 4, Section 6, Section 8. Study that, but study that as well in conjunction with the circular. The Value Added Tax Act, I think that act you study in conjunction with your Transfer Duty Act. Usually they ask you which transactions are VAT that attracts VAT? If it attracts VAT, at what percentage? What are the requirements for zero rating, etc.? And that, ladies and gentlemen, is the schedule. The other acts that they say 10%, that's the housing development, the less formal township, 113 of 1991, that act has been repealed, that you can draw a line through. The Restitution of Land Rights Act, Upgrading of Land Tenure Right Act, look at those acts. So that brings me to the end of my session with you. I do hope that these 4 sessions did help you. And those of you that feel, I'm just not ready for this exam, do yourself a favor. Say to yourself, you know what, I'll rather write in September. I'll rather now take this knowledge that I have, prepare properly, and then do a good job of it. Instead of now writing and wasting your time, wasting the examiner's time, and not knowing how to answer these questions. I think you've got a good idea what's expected of you now. So I ask, are there any further questions? And then the one guy, I'll never forget it. I think I told you this before. The one guy sat in my exam room, and every Monday evening he would say, is it now too late to start studying for the exams? And, I usually had, I think it was a 3 months or 4 months course. And every week I would say to him not. And the last week he put up his hand again and he said, is that no te laat? And I said to him, it's now too late. So if you're going to start studying now for the exams in 2 weeks, I can tell you it's too late. The other person that, I said, is there any last questions? And the person put up his hand and he said, yes, sir. Will you pray for me? I said, you guys are in my prayers every evening. So believe me, you're in my prayers, but you have to do your duty to be able to get through the exams. Prayers is not going to get you through these exams. Hard work is going to get you through these exams. Are there any final question that you want to ask me before I say good night to you? Zukili, you want to ask?
Someone said you're going to send this information.
What information?
I don't know, the recordings for those who didn't.
Sorry, that is Mr. Modiba. If Mr. Modiba has recordings of this, I do not know. I'm only the presenter. I don't send anything. I see that the sessions have been recorded. So, Mr. Modiba, you'll have to contact LEAD, specifically Mr. Modiba at LEAD, and ask him if he can send you the recording.
I see Mr. Modiba is there. Can you confirm?
Andries, can you confirm? Andries? I see his photo is still there.
Yeah.
Maybe he's gone to the toilet.
Yeah, but I think that's what I heard last time, that I think he said you will send this to all.
No, not me. I can't send you anything. I've got nothing. Yeah. I've got no recordings. This gets done by I'm only the presenter.
No, Mr. Modiba said I think he will. I think to all the participants who need that.
Maybe you'll send it, but not me.
He actually said the classes are only recorded for Mr. Alan West, so it's not distributed to the attendants.
But why is it recorded for me? I know everything of this. I don't have to see my recording.
I don't know. I think he mentioned if you want to might keep it for your records or something, but he definitely said it's not distributed to us.
Okay, so look, I've got no control over this, if you understand what I mean. I'm only the presenter. They employ me. And with all due respect, if they want to send it out to you guys, that's their prerogative.
All right.
Can we maybe ask Mr. Anton Theron one last question?
He's sitting behind me here and he's saying to me he wants to go home.
I just want to take one shot and just find out. I got a heart attack
you can ask. You can ask.
Okay. So I got a heart attack when I went through 2018's paper. I think it was September's paper. And I just want to know, can we expect another donation question like what was asked in that paper?
To draft a deed of donation, I remember that paper. But Lisa, can I just ask you, What is difficult in drafting a deed of donation? If you can draft a deed of sale, you can draft a deed of donation.
It's true. It's just one extra thing. My mind is already so full of stuff. I don't know. I didn't focus on it as much as the other stuff, and to study it, I'm trying to, but it's not getting in my head. So.
I understand, but I'm preempting now. I'm going to leave it up to Anton to answer that question.
Yeah, unfortunately, it forms part of the syllabus, and I cannot say you can leave it out. I'm not saying it is in the paper, but if you go and sit down and take 5 minutes, you'll be able to prepare properly to be able to draft a deed of donation.
Okay, I think it's just about the exact wording of the examples, but I mean, I think if you have it more or less what it must contain, you should be fine.
Yeah, 100%. Look, what is a donation? Somebody donates and somebody accepts. So that's basically it. And you can write around that. You can do what you have to do.
Yes, definitely. Thank you so much.
Okay.
Guys, then I'm going to say to you good night and good luck, and we're holding thumbs for you. All the best. See.
Good luck.
Good luck.
Bye.
Thank you.